All right, class. Today I'm reviewing Chapter 8, Law and Ethics in Media Writing. Now, the First Amendment says Congress shall make no law respecting an establishment of a religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So, what does this mean in terms of media publication? It means that you are free to voice your opinion. However, there are some limitations on that freedom. The first are what we call categorical limitations. Those mean that you have limitations on the content of your message. So if you are threatening someone or you uh, have what are called fighting words with them, those would not be protected. You cannot threaten another person's self. You also have to make sure that if you're advertising something, you aren't making false claims. Now, when we talk about false claims, we mean something that is a believable lie about a product. So if you have a sugar pill and you say that it's aspirin when it clearly isn't, then, and this is not in a study, this is this is something you are just selling to the public, then that is considered false advertising. Criminal solicitation and exploitative works are also things you are not allowed to do under the right of free speech. And exploitative works include child pornography. If you have any kind of revenge porn situation, that is also considered exploitative and is not allowed. Now, medium-based limitations are how you deliver your message. So depending on the medium you use, if you are using a podcast, if you're using a newspaper, if you're disseminating your message using an email or radio or TV, it's all going to have different limitations based on how you're expressing whatever you're expressing. Now, newspapers have the broadest amount of protection. They were here before our nation started, even, and their their protections now are often included in the ones for internet publications. So, most newspapers and internet publications will have the broadest amount of protection. TV and radio are both governed by the Federal Communications Commission. And the reason theirs are more limited than newspapers is because they're using public airwaves. When you watch TV or radio, even if you're looking at something that is not a public radio station or a public TV station, all of those companies are essentially borrowing airwaves from the federal government. So they have to pay for the airspace they're using, and part of their payments and everything is the agreement that they will abide by the Federal Communication Commission rulings or any other limitations that are put on them. Now, public relations groups, advertising, and satellite or cable broadcasts all have their own organizations and their own ways of keeping track of whether or not someone is following the rules. So all of them are a little different depending on how you're delivering your message. There are also time, place, manner limitations. So the when, the where, and the how of a message can all limit what you're able to do or say. Now, for example, whenever we're talking about balancing the rights of the public versus individual freedoms, look at noise ordinances in neighborhoods. If someone goes through the neighborhood as a form of protest, honking their horn and screaming out their window at 11 p.m., then the cops will probably be called because these people are violating a noise ordinance. Depending on where you hold a public display, if you are on a sidewalk, you are on a traditional public forum and therefore will probably have more rights than if you try to go actually in the street where traffic is flowing, or if you are on a school's property or a public school, and especially if you're on a private school property or a private organization's property, then you have different types of limitations. Now, no one can stop you from publishing what you want. Well, obviously, this isn't true. The First Amendment specifically addresses Congress. However, this has been interpreted to mean the government in general. So the government is not allowed to impinge on your freedoms. They are not allowed to limit your First Amendment freedom of speech other than in the ways we mentioned earlier. Also, if there are any sort of national security concerns, then they are also allowed to stop you from publishing anything and everything. There are certain guidelines still, even in relation to the government, as far as gag orders or, again, national security concerns. But the biggest misconception is that no one can stop you. Well, you can be stopped by social media user agreements. Social media is not a public forum. It's semi-public in the sense that a lot of people are able to view it. However, when you sign up for social media, you have to abide by that organization's user agreements. Same thing when you work somewhere, or if you are part of a newspaper. If you are violating any employee conduct codes, then they are allowed to let you go, or whatever is happening in that particular situation. Freedom of the press protects you from consequences of publication. Obviously not true, especially for any of you who have published something controversial before on social media and you had relatives who saw it or friends who decided you weren't going to be friends anymore because of it. You're still facing consequences. So the court of public opinion will still hold you accountable. We've seen that a lot, especially for people who are well known. Whenever they publish something that a person finds offensive, and then apparently hundreds or thousands of people also decide that it's offensive as well, then you are held accountable in the court of public opinion. Also, if you knowingly submit false information, if you violate the False Claims Act, you are claiming that your product does something that it doesn't. That is a categorical limitation. That's something you cannot do because you are making a false claim about a product, or sometimes even if you're making a false claim about a person, as we'll see in a minute, you also will face consequences of that publication. And again, if you violate any kind of code of conduct, we're talking about school, work, any kind of website or online organization, you will face consequences. Usually, if it's an online group, of course, you get kicked out. If we're talking about school or work, you might be reprimanded in some way. A lot of times, you'll end up with detention, especially if you're in a private school and you're out of uniform, or if you're at a workplace or something and you violate the employee code of conduct or publish something violating the code of conduct, then obviously there will be consequences. First Amendment rights are absolute. as we've seen, there are some variations. There are different things that will change depending on the situation, depending on where you are and when it happened and all of the circumstances around it. So another thing is courts. The court system can overrule, higher courts can overrule the rulings of lower courts. So if something goes from state court to circuit court, the circuit court can overrule something from the state court. If the circuit court case goes all the way to the Supreme Court is able to overrule the circuit court's decision if they so choose. They are also able to possibly change a previous ruling based on newer information if they feel like a previous ruling wasn't fair or didn't uphold the letter of the law in the way that we interpret it now. Then they might retroactively change a ruling. And one example that's happened in the past few years is the Supreme Court reconsidering New York Times v. Sullivan. And we'll look at that case in just a second. The First Amendment only applies to professional media. There are no professional media. Technically, yes, there are some who have been around for a very long time, who have built very strong reputations with their readers or viewers. However, there is no licensing process in the United States for journalism. That is one of the freedoms. Everyone is able to publish things if they so choose. However, with the protections and rewards of that right to publish or offer free speech, they also assume the risks of publication. So keep that in mind. You do not have a particular licensing requirement. However, you are also assuming the risks along with the rewards of publication. Now, one of those risks is the risk of a libel suit. Now, what is libel? It's a written form of defamation. So you are saying something untrue about a person, and they noticed and say that, hey, this person wrote this article, they mentioned me in it, and they say something that is completely untrue. So I'm going to sue them to issue a retraction and for any damages they may have caused. That would be a type of libel suit. Slander is traditionally the spoken form of defamation. So if someone says something that is untrue about you, it's slander. If it's written, it's libel. The 6 key parts of libel are identification, publication, falsity, defamation, harm, and fault. Now, identification, that means the person alleging libel. So the person who is suing someone saying that the other person published something untrue about them needs to first prove that they were actually targeted. And this can be if their name is mentioned. It can also be if they occupy a unique position. And an example would be if they are the head of an organization, if they're the CFO or the CEO or whatever, or if they are a political opponent, especially if, let's say, they're trying to say, oh, well, I mentioned all of my opponents. Well, if they specifically mention a thing only attributed to the person who's suing, then they are being targeted by whatever was published. Now, publication, there has to be a public dissemination of information. And what that means is a large group of people have to be able to view the information and to have access to it. This could mean a mass email if someone made a video about it and posted it online or sent pictures with a caption. That's another example. Social media post, newspaper or magazine articles. It could even be a billboard or if someone hands out flyers. All of those are considered publication. Falsity. The plaintiff must prove the statement is false. So you have to prove that whatever it is untrue. And sometimes this can be very difficult, especially if it's about an event where only one or two people were present, and you have this one person on one side who says it happened, and you're the other person who was there and you're saying it didn't. And there's no tape or anything to prove whether or not it's true. It's assumed true until proven otherwise. Minor factual errors or grammatical mistakes do not qualify as falsity, especially if it's just a little error, like if you put she instead of he. Well, in general, someone reading it will probably know how you identify, and so it wouldn't be as big of an issue. It's but this is also a very big reason why it's important to check your work, make sure that you are attributing all of your information correctly, and to make sure that there aren't any grammatical errors or any other issues with your writing. Defamation, so you have to prove that whatever was published damaged your reputation if you're suing for libel. That means that they accused you of doing something like participating in illegal activities, or maybe some kind of extremely socially unacceptable conduct, or maybe they went around and said that you have some kind of disease and or something. If it's untrue and it's damaging, then it's more likely to be a good case for libel. Now, this is an example from Parks and Rec. They had the head of their health organization published these banners and put them all over City Hall about his wife. Now, if this is true, then it isn't technically libel. It's just extremely bad taste. But if it is untrue, then yes, it would be considered defamation, and it would be grounds for her to sue him for libel. Now, harm, you have to prove actual damages. You have to prove that not only was this false claim published and that it was a very damaging claim, but also that there was an inability to earn income, or you had some sort of undue emotional suffering because of the claim. Now, one example is when ABC ran a story about pink slime in ground beef. The beef industry sued ABC over the pink slime, and they also sued for punitive damages. Now, what that means is because ABC is such a big organization, they were sued not only for spreading this information, they were also sued for, in addition to actual damages, because the beef industry wanted to make sure that they were discouraged from publishing any stories like this in the future. Now, you also have to prove fault. So they either did something or failed to do something that led to libel. So the publisher can either openly act in a hostile way, or they can act in a neglectful way and not do something that still led to this publication. So something within the realm of reason, usually, which is getting more into a case-by-case basis. The reason we have to prove fault and prove negligence is because of the chilling effect. You'll see this in different cases. This is when someone is trying to sue for that they keep suing for libel in order to stop people from publishing stories that end up being true, but or having some other grounds in reality, but they are trying to keep them from being published. So if a person did actually steal money while he was in office, but he's going to sue a local newspaper for running a story about it, then that would be kind of a chilling effect issue. And that's part of why you have to prove that someone did that they made a false claim on purpose, and also why it has to be big enough to actually cause damage. Now, another component, actual malice, means that the publisher acted with reckless disregard for the truth. And this is important for public figures. So if you're a public figure, not only do you have to prove that this person either did something or failed to do something that led to the libelous claim being published, you also have to prove they were doing it as in kind of a sensationalist way where they didn't care and they were being extremely reckless, and because it didn't matter to them whether or not it was true, they just wanted to publish it. Now, an example of libel is New York Times v. Sullivan. So the New York Times published this ad, Heed Their Rising Voices, supporting Martin Luther King Jr. and his associates who had been arrested. And it did contain minor factual inaccuracies related to the arrests. Because it had these inaccuracies and also mentioned the Public Safety Commission in it, the head of the Public Safety Commission, L.B. Sullivan, filed a libel action against the New York Times. Sullivan won $500,000 in state court, and this decision was appealed to the circuit and then Supreme Courts. And the Supreme Court of the United States asked, was Alabama's libel law unconstitutional? Now, they voted unanimously in favor of the New York Times. The court concluded they needed to prove actual malice. So this is where the actual malice portion comes from in relation to the ad being printed. So a quote from the decision, the target of the statement must show that it was made with knowledge of or reckless disregard for its falsity. So even though this was an advertisement and not an article written by the New York Times, if they had shown in some way that there was a reckless disregard for the ad's falsity, then that would have been actual malice and they would have been held accountable. However, they were not, so the court decided in favor of the New York Times. The Communications Decency Act of 1996 has several components, most of which were found unconstitutional. Section 230, however, remains, and it protects third parties who pass along content online. That means internet service providers, websites where commenters make libelous statements, online sellers if they have people who sell forgeries, and content hosts as well. So technically, social media organizations are still mostly protected from any libel suits through Section 230. However, this does not apply if a website creates the libelous content. So if instead of it being a libelous commenter, if it's a libelous post by the website, then it would be grounds for libel. Online anonymity. The Supreme Court supports the right to anonymity. Now, this started with a person who was distributing flyers in Los Angeles, and he was he didn't want to put his personal information on all the flyers, and that law was considered unconstitutional. Now, whenever you post online, the majority of the time you are not required to disclose your actual name or address or any of that information. Whenever a case is considering unmasking an anonymous source, they use the modified dendrite test to determine whether or not it's necessary. There's an attempt to contact the commenter and allow reasonable time for a response. They identify triggering comments and then present enough evidence to show a plaintiff has a case and provide evidence for each step of the defamation claim, except actual malice. When, unless you're, of course, a public figure, then you do need to have actual malice. So once they've done all of those things, the court may still not require the disclosure of an anonymous source. It really depends on the case and is very, very much a court-to-court basis. Now, there are different rules regarding information published for publicly traded companies. You can't comment about a company if you are a like the CFO or the CEO of a corporation, and you post something online that changes the stock market price for your organization, then the court is allowed to disclose that you were the person doing it. So they are able to unmask the anonymous source whenever it affects stock prices for an organization, for a publicly traded organization. Now, fair use allows unlicensed use of copyrighted work under certain circumstances. And those circumstances, of course, will be evaluated on a case-by-case basis. This includes the purpose and character of the use. Is it for a commercial group? Is it a nonprofit thing? Is it going to be widely disseminated? Like, are people going to be publishing it everywhere? How much is being copied of the original work? What is the original work? If it's an audio recording, then you have different rules compared to a cartoon or a comic figure. And what's going to be the effect of this publication on the original work? Is the original work's value going to decrease because this new work was published using part of it? And because there are so many variables, that's why courts evaluate this on a case-by-case basis. Now, when you're approaching an ethical dilemma, there's a 4-step way to approach it. First of all, assess the situation. What's going on? Identify the values and points of view within the case. So this is kind of what's happening. If you're publishing for a news group, have you covered all of the points of view in your story, or are you planning to address it in that way? Make sure that you are covering as much as you reasonably can and that you have reliable sources of information. Discuss what's happening with others. And then, of course, at the end, you are the one putting your name on it. Make sure that you are comfortable with whatever happens. An example is when you see product reviews or mentions online. This happens a lot, especially when you see more popular TikToks or Instagram people. Then they're given free products or they're paid to endorse particular items. And the best course of action usually is to disclose you were offered some some kind of compensation for your review, if you're going to review it at all. And there are some different variations on the ethics code relating to various topics. You can find them on the SPJ website. They also list information related to advertising, and I believe they also have public relations on there as well. All right, that's it for chapter 8. I will see you guys later.